Welcome to Laws 11046 and Laws 19038. Tonight we'll be covering three chapters from Bates' Environmental Law in Australia. I'll be referring to the current edition, which is the 8th edition. Starting firstly with Chapter 15, which deals with pollution, waste and contaminated sites. It goes from pages 597 all the way through to page 702. So in terms of volume, it's a huge chapter. I won't be covering it in anywhere near the same detail that I usually do in these commentaries, so I'll move fairly quickly. There are, as you will see in the heading, 4 parts to the chapter. Pollution control, Part A. Part B is management of waste. Part C is contaminated lands. And Part D, international obligations. So a few comments in relation to Part A, pollution control. Now this caters for the bulk of the chapter, from page 597 through to page 661. And Bates makes reference to the national policies for management of pollution and some commentary in that regard. But I'll take you through to where I've selected as a starting point for comment, and that is on page 616, which is paragraph 15.35. Legislation in Queensland stipulates that a person must not undertake an activity that pollutes or might pollute the environment unless that person takes all reasonable and practicable measures to prevent or minimise environmental harm. That's the EPA Act of 1994, section 319. Now, that is an extraordinarily wide provision. When you think about it, legislation prohibits a person from undertaking any activity that pollutes or might pollute the environment. Well, it wouldn't be hard to suggest that most people are potentially guilty of that every day. Driving your car might arguably be an activity that pollutes or might pollute the environment. So it's very broadly drafted. 15.36, failure to comply with the duty does not of itself give rise to criminal or civil liability. That's section 24(3) of the Act. It only refers to civil liability, but a similar position arguably applies in relation to criminal liability. It may be a defence in criminal proceedings alleging failure to comply with the duty to prove that the pollution was covered by the terms of an environmental protection policy or licence or other authorisation, or it was an act carried out pursuant to a lawful activity in compliance with a general environmental duty. I mean, that type of concept we see in the criminal law generally. So, for example, let's take a parallel situation, say, of someone charged with an assault. Well, there are assaults undertaken every day, everywhere in Queensland, and never would prosecution consider commencing actions. You go to your dentist commits a heinous assault, certainly an assault occasioning bodily harm, and by the removal of a tooth or something else, perhaps even a grievous bodily harm. But, of course, it is authorised and there is consent. So Bates properly makes the observation that even though you might be committing an offence by doing something which pollutes or has the possibility of polluting, that does not necessarily mean that you are committing an offence, despite the wide wording of the section. We'll go through to 15.80. It's page 642. Dealing with pollution control. Pollution control legislation generally describes an environmental audit as an assessment of or investigation into or evaluation of the sources, causes or extent of environmental harm. Over the page, in Queensland, if an activity has caused environmental harm, an environmental investigation may be required. That's section 321 of the Environmental Protection Agency. Audits and investigations are collectively referred to as environmental evaluations. So what we're really saying here is that documentation may come into existence as a result of monitoring and auditing of environmental activities. At 15.84, Bates makes reference to the question of confidentiality of those audit documents. So the main difficulty, he says, with the widespread use of compulsory audits is that the use of heavy criminal sanctions as a deterrent may force firms to protect their own interest by adopting an approach based on minimal cooperation and the revelation of as little as possible. He makes reference to the well-known decision of Caltex Refining in 1993, a High Court decision, and also a Federal Court decision to the effect that corporations neither enjoy a privilege against self-incrimination nor a privilege against self-exposure to a penalty. What that means is this: if a company voluntarily undertakes an audit that reveals deficiencies which might be used to support a prosecution, those audit documents are likely to be seized, then this will clearly discourage voluntary audits. Corporations may turn to legal professional privilege to protect confidentiality. The privilege attaches to the communications made in confidence between a lawyer and a client, but only for the sole purpose of obtaining legal advice or use in litigation, existing or anticipated. Again, that's Grant and Downs. Privilege cannot be claimed for documents which were merely given to the lawyer in order to provide advice if they did not come into existence for that purpose. Audit reports and results of investigations will therefore seldom satisfy this test. Only communications in documents may be privileged, not the facts contained therein. Steps have been taken, therefore, to protect voluntary environmental audits by precluding their seizure and use in evidence in proceedings. All right, that's all pretty heavy. It's getting into some sort of detailed legal work there. But when we talk about privilege, we're really talking about a claim to withhold documents from an investigating authority on the basis that there's lawful authority to withhold those documents. So if a lawyer provides legal advice, even if it's in writing, that always remains privileged. It can't be seized or attacked or used against the party. But the point that Bates is making there is that some things, even though they might involve lawyers, and even though they might involve lawyers giving advice, did not come into existence because of litigation, and therefore that usual privilege does not apply. However, so what he's really saying is there needs to be a balance between the rights, if you can say that, of the company to withhold information or be protected if it's trying to do the right thing in disclosing documentation which provides for possible environmental damage done or to be done. Over the page at 646, in reference to the EPA Section 351, corporations will be protected from prosecutions in relation to giving a program notice about an act or omission which constitutes an offence. In return for protection, the program notice must declare an intention to prepare transitional environmental program. So it is possible, by use of this technique of program notices, to avoid prosecution, but it comes at a trade-off, and that trade-off is that the prosecuting authority can seek a commitment from the company to undertake a transitional environmental program. Clearly, a decision to prosecute will involve balancing the regulatory authority of the gains to be made from prosecution against the advantages of pursuing a voluntary approach to compliance. So really what we're saying there is that there's a wide discretion available to prosecuting authorities upon being notified or detecting a breach. There is no absolute requirement or duty to prosecute. There is this opportunity to come to an arrangement in terms of compliance to resolve the issue, and that may be, if you like, for the public interest or in the public interest or for the public benefit, and provide a much better alternative than litigation. I'll take you through to 653, that's page 653, dealing with criminal sanctions. Now, Bates says these are detailed more in Chapter 18, but enforcement policy adopts the key principle of ecologically sustainable development, that the polluter shall pay. That is, those that generate waste or pollution shall pay the real cost of avoidance, containment or abatement. He then goes on to talk about strict liability offences, which means that evidence that the offender had a particular state of mind is not relevant to liability. The offender is liable for committing the act that constitutes the offence. So in other words, I didn't mean for this to happen. I didn't mean the environmental harm that's been caused to the reef. That doesn't matter. The fact is that you did undertake an act that caused the environmental harm, and therefore you are strictly liable. And Bates categorises most offences as being offences of strict liability. He then, in the third dot point, says evidence of a guilty mind by way of intentional, reckless or negligent conduct would enable the regulator to prosecute for a higher level offence, and therefore there'll be greater penalties and maybe even jail. Now at the bottom, this is should be taken heed by corporate managers because they can be personally liable for offences committed by the corporation. Over the page, regulators have a discretion as to when and who to prosecute. We talked about that before. Courts are given a wide range of penalties, and principles of sentencing demand an even-handed approach. I'll go through to page 659, dealing with court orders. Courts do have a wide range of remedies available to them. Traditionally, in criminal law proceedings, we see a lot of imposition of fines, imposition of jail terms, community service orders, probation orders, good behaviour bonds, etc. But in environmental criminal law litigation, courts have a much wider discretion. They can ask for work to be done by way of restoration of the environment, take specific action to publicise the contravention, and pay for various costs associated with taking the action to remedy, or even costs associated with injury, loss or damage reasonably incurred. And that's Environmental Protection Agency Act, Section 501, 502 and 503. All right, that's all I propose to talk about on pollution. Part B deals with waste management. That runs for a few pages. I won't be making any comment in relation to it. Now, of course, if I'm not making any comment in relation to it, those of you doing Laws 11046 might rightly regard that as a reasonable exam hint in itself. We'll go through to 15.171, and you'll note that even though I'm skipping through chapters, almost every time I deal with issues of criminal liability and issues relating to bringing criminal actions, I am emphasising, so that might be construed as an exam hint. Federal and state legislation makes it an offence to unlawfully discharge oil or oily substances into the marine environment. Although fines may be significant, clean-up costs are likely to far outweigh the criminal penalties imposed. Okay, unless you have any questions, that's all I propose to talk about in relation to Chapter 15. Let's move on to Chapter 17 at page 739. This is to do with the concept of standing in environmental litigation. Of course, when we talk about standing, we don't mean literally a person who is standing, but it means that concept of being able to bring a cause of action in the court. Now, a good cause of action gives no guarantee that the complainant will be able to present the case. The right of a person or body to ask a court or tribunal to hear a case is often referred to as standing to sue, or the Latin locus standi. The purpose of standing is to ensure that only those who have a legitimate interest in a matter are allowed access to a court or a tribunal. Over the page, the task for legislators, as well as courts, is to define more particularly the circumstances in which the environmental interest might translate into a right to have a matter heard by a court or tribunal. The right of standing at common law traditionally also depends on the precise remedy sought by the plaintiff. 17.4, legislation may, of course, confer standing on parties to bring court actions to enforce the law or allow them to contest the outcomes of decision-making by lodging a merits appeal. I'm just going to stop there for a bit You remember that Roger Curry, in his excellent overview of community-based litigation, said that the issue of standing had to be overcome, and he explained that that's not something that can be taken for granted in general terms. The second thing I'll comment on is merits appeals. And you'll recall that a number of times during the course I've made the distinction between a merits appeal and a judicial review. A merits appeal is where an administrative decision is essentially reheard, but reheard afresh, as if the tribunal or court hearing the merits appeal had stepped into the shoes, so to speak, of the original decision maker. A judicial review is different, and it's where one is challenging the way in which the law had been applied in relation to a specific decision. So judicial review says, irrespective of the conclusion you came to, you went about it adopting the wrong legal principles, whereas in a merits appeal we're saying, well, look, we're just going to scrap that decision and have the whole thing reheard again from scratch. Now, going back to Bates, standing that is conferred on persons aggrieved must therefore be interpreted to determine how far the legislation intended to go in conferring standing. It's not an easy task. It's also usually the case that statutes that confer these rights do not provide any interpretation of what is meant by a person aggrieved. Consequently, says Bates, legislation that gives rights to persons to enforce the law or bring a merits appeal has often been restrictedly interpreted so as to reflect this common law view. At 17.5, in recent years, the strict approach has been considerably relaxed both by courts and by legislation. The courts may admit that while the rules of standing are legitimate and valued at court proceedings, it is necessary to reappraise the common law rules in light of modern social expectations. Legislation may define more precisely who is entitled to enforce or participate in a statutory scheme, and there's reference there to EPBCA and the EPA at a federal and state level respectively. And legislation may effectively abolish rules of standing and give standing to everyone. Any person may enforce the law, and that's the kind of somewhat enlightened approach that's been adopted in New South Wales. That's likely to continue, I should think. Now, Part A deals with the common law or the traditional approach, and it's all to do with property rights. Do you remember we talked about common law as being associated with rights of property, and it didn't acknowledge environmental law as such? So if we were to consider the question of standing to sue from a common law perspective, it comes as no surprise then if I say that it's based on property law interests. So at 17.8, traditionally a litigant seeking to enforce a public environmental duty has to show some special interest. This is at common law over and above other members of the public. Environmental laws create public statutory duties owed to the public at large, and this goes back to very old principles. If we look at a 1903 decision of Boyce, in that case Justice Buckley said a plaintiff can sue, but only if they suffer some special damage peculiar to himself with the interference for those rights. Sorry. Now, 17.10, since the common law is based essentially on protection of private rights, it's not surprising that a person has to assert a private property or economic interest in order to have a special standing. That's at common law. And at 17.13, due to difficulties associated with environmental groups being able to establish a traditional basis for standing, that is a property interest, they have at times tried to assert economic interest as a way of getting around that difficulty, sometimes quite colourfully as well. Now, there is opportunity for people to allege that they have social or cultural interests which should be taken into account. And at 17.15, there's reference to the Australian Conservation Foundation against the Commonwealth, where such interests can be a special interest. In 1981, the High Court agreed that an Aboriginal cultural interest was sufficient to allow the applicant to have standing to challenge the construction of a refinery on sacred land, even though they may not be able to establish that they had any property interest or economic interest. Now, contrast the common law position with statutory rights and entitlements, and here we see, generally speaking, a much wider opportunity for parties to have standing to sue. Starting at 17.17, the common law recognises that persons who have the rights conferred on them by environmental statutes, that is a right to lodge a merits appeal, will have standing at common law to protect those rights. At 17.18, one must be careful to distinguish between legislation that confers rights to continued participation in the process from that which merely allows submissions to be made without any further right to continued involvement. So just be careful about that in terms of submitter appeals or objector appeals. One example of that might be from a planning perspective. You'll all be aware that where a particular application is code assessable, then objectors do not have the right to appeal the decision through the Planning and Environment Court. But if the application is impact assessable, then submitters, or objectors if you like, do have the right to issue proceedings in the Planning and Environment Court. So there is that difference. Now, Part B, standing generated by legislation. At 17.20, environmental legislation gives authorities standing to initiate action, administratively or otherwise, and also it gives applicants for a licence a right to appeal, and rights of appeal for objectors. They're more sparingly used, but they do occur. At the bottom of that paragraph, you'll see reference to the New South Wales position, where any person may bring proceedings to enforce or restrain a breach of environmental statute. That's New South Wales. Now, that's extraordinarily wide because the opportunity to bring action to allege a breach of the law is usually confined to authorities such as the police or departments such as fisheries, etc. The legislation that allows any person to bring proceedings to enforce or restrain a breach of environmental statute is, one might say, enlightened, but also risky in that it might open the floodgates, so to speak. All right, let's move forward now to 17.28, which deals with modification and expansion of the standing rules. There has been a reappraisal by the courts, and generally they're more prepared to admit that applying the rules of standing is not necessarily appropriate when we're dealing with public interest cases. So all those laws at the common law were all about private interests, whereas the courts are now much more keen and much more amenable to allowing public interest litigation to be commenced by other people. At 17.30, there is reference to the Australian Conservation Foundation case, and Justice Davies concluded that ACF had standing. It was to do with logging, and they said logging was a major environmental issue. Disputes were regarded as part of the national estate, and courts are allowed to take into account current community perceptions, and ACF was a major national conservation organisation. So remember Roger Curry talking in terms of what needs to be established so that the court is satisfied that the applicant or the appellant is of such a standing as to warrant hearing them. At 17.33, in all cases, no particular factors appear to have been singled out as essential to determine whether or not there's a special interest. But in the end, the appropriate question may really be whether the applicant is an appropriate organisation to ensure accountability of the decision maker in the statutory decision-making process. And that's midway through 17.33. Over the page at 17.35, Bates makes reference to One Steel against Whyalla, where most of the people worked in or around the area where dust from the plant was being emitted. And this is extraordinary. On appeal in the Supreme Court, it was held that the group was unable to demonstrate any interest that might be affected by the subject matter of the application other than an intellectual or emotional interest in the protection of the environment. So, notwithstanding the flow of the cases, that one from 2006 seems to fly in the face and seems to halt the usual progression that we've been discussing. Over the page, Justice Chesterman in Queensland decision, North Queensland Conservation Council case, indicated that he preferred an alternate approach, and this was to ask whether the applicant's action was simply an abusive process. Now, there have been some statutory relaxations to the standing rules, and Bates makes reference to that at 17.37, 17.38, referring to New South Wales in particular. On to 17.42, following the lead given by the Federal Court in the woodchip cases, the Commonwealth regained the initiative on standing. EPBCA continues to reform and extends the test of a person aggrieved to persons and organisations that in the last 2 years have engaged in a series of activities in Australia for protection or conservation of or research into the environment, and that's section 487. So can you see through this chapter this progression from 40 years ago, where we didn't have environmental law, and if you wanted to pursue action in a court in relation to an environmental law issue, you really had one recourse, and that was to rely on the common law and argue that you had a special interest. Progressively, through case law and legislation, that has been extended and enlarged so that it is now far easier for a person to come to a court and argue that they should be heard in relation to an environmental law issue. There is a possibility of taking action by or with the consent of the Attorney General, and that can be a case which we call a relator case, and that's 17.44. And just over at the page at 17.47, the class or representative action may be a useful means of litigation. So you're all familiar with the situation where a class action is taken, usually by one law firm representing many people, sometimes many hundreds of people, in relation to a common action. And by having a class action, that provides that opportunity for many people to be heard at the same time. All right, unless there's any questions, that's all I propose to ask or comment about in relation to Chapter 17, Standing. Right, let's move on to the last chapter for tonight, Chapter 18, which deals with enforcement issues from pages 771 through to page 837. Regulatory authorities may enforce environmental laws in 3 different ways: administrative orders, prosecution, or seeking civil remedies. These are all available, and it's for the regulator to determine what is most helpful and effective. It's not unusual for an administrative order to be followed by prosecution, so there might be an escalation. These forms of actions are recognised by the remedies that are being sought. In criminal law matters, it might be a fine or jail. Civil action, it might be damages. It might be a request for an injunction, that is to stop a certain course of action. or in administrative orders it might be requesting restoration or rehabilitation for harm done. Of those three, Bates starts with administrative remedies on page 772, where at 18.4 he says, where an incident occasioning environmental harm occurs, or the regulator believes that an incident might occur, the regulator may issue a notice or order requiring specific conduct to be stopped or prevented, or requiring certain positive action to be taken. Now again, that's extraordinarily wide. That administrative power is something which provides a great opportunity for regulators to deal with issues that are in existence or looming. Over the page, a person served with an order generally has a right of appeal on the merit, which is in Environmental Protection Act section 519, which means a request that the decision to issue the notice be reheard or reconsidered from scratch. 18.5 is a paragraph that deals with the issue of separation of powers. The power to issue such orders is constrained only by the legal principle that the orders should reasonably relate to the particular activity, and the content should be within the powers conferred by statute. If that wasn't the case, then regulators could effectively amend existing legal standards without parliamentary scrutiny. So I started by saying that the power of regulators to issue these administrative orders is extraordinarily wide on its face, but you'll see that in doing so, they must be constrained by the delegated power conferred upon them through the relevant legislation. Let's move to page 776, which deals with civil remedies. So where there's been a breach, there are disadvantages through enforcement in criminal law. It's effectively reactive. There are penalties, and it's likely to impose a penalty through a court which is less than might be the object of compensation if the matter was treated through the civil courts. So civil enforcement may be undertaken by regulators, and it's also a way for members of the public to be involved to a greater degree. Now at 18.14, as an alternative, legislation may specify that certain provisions may be treated as civil penalty provisions. This has the advantage that the offence only has to be proved on the balance of probabilities. I'll just stop there, that's an important point. If a regulator chooses to issue criminal law proceedings, the usual criminal law onus applies, and that is that they must prove that the defendant/respondent is guilty beyond reasonable doubt. If they're pursuing civil action, all they have to do is prove that it's more likely than not. And that's a big difference and far easier. So that might be a great incentive for the regulator to take civil rather than criminal proceedings against an alleged perpetrator. And there's some flexibility in terms of what can be done. So at 18.18, an alternative to court-imposed remedies is undertakings, and that can have some particular advantages, and enforceable undertakings have been introduced into the EPBCA. The use of undertakings should free up regulatory resources that would otherwise be focused on other forms of enforcement. In other words, by pursuing an undertaking, that's going to save a lot of time for the regulator and therefore considerable saving to the public purse. Okay, so that's the first part, which deals with the administrative or civil remedies. So we've dealt with Part A is administrative, then Part C is civil, which leaves Part B criminal, and this is the rest of the chapter. So the threat of criminal prosecution has always been the backbone of legal enforcement of environmental laws and other laws. Bates makes this comment. For a long time, environmental offences were not regarded as real crimes. That is, not criminal in any real sense, but in which the public interest was prohibited under a penalty. and he refers to an old case. At 18.24, in jurisdictions that send environmental criminal offences to magistrates' court rather than specialised courts, it is difficult to collect data because often the reports are not recorded, the records are destroyed quickly. In practice, Bates says, criminal enforcement is the sole domain of government regulators. We talked about that before. Minor environmental offences are generally specified as summary offences, more serious specified as indictable offences. I'll just stop there. Summary offences are matters which are typically dealt with, in fact exclusively dealt with in real terms in the magistrate's court. Indictable offences are matters which can be the subject of an indictment, and an indictment is a document that initiates court proceedings in reality in the superior courts, the district court and the Supreme Court. So less serious offences are regarded generally as summary offences, and more serious offences are regarded as indictable offences. In Queensland, the Environmental Protection Act creates an indictable offence where the maximum penalty is 2 years or more. So it's a bit arbitrary. Proceedings generally have to be commenced within 6 months to 3 years after the date where the offence was committed or first came to the attention. And in practice, regulators treat criminal prosecution as a last resort. Just in terms of assignment feedback, I've made mention on a number of papers that I'd like to see some commentary. What I mean by that, I guess, is two things. Firstly, you can add your own flavour to the paper, or you can interpret and explain what's being said. So 18.27 is, I think, a very good example of what I'm trying to say. Bates has given us the legal position, but then very helpfully has said regulators treat criminal prosecution as a last resort. So it's an insightful comment which goes far beyond simply reciting what the law is. Okay, let's move on to page 788. At 18.31, to prove a criminal offence, the prosecutor has to establish beyond reasonable doubt. We talked about that. Where the accused is charged with a result offence, the prosecution must prove cause and effect, and that is that the result was caused by the conduct of the accused. At 18.36, there's comments in relation to privilege. We talked about that in chapter 17. The privilege against self-incrimination is designed to protect individuals from oppressive methods of obtaining evidence to support a crime. And again, he refers to the Caltex refinery case. At 18.37, Bates starts to discuss the issue of directors and managers, where they have a personal right to privilege against self-incrimination, and that generally, but in terms of company documents, is still unclear. Now, classification of offences, we've talked about this a bit already. 18.41, statutory offences can be classified as, firstly, those in which mens rea applies in full. Mens rea means intention, specific knowledge to undertake a certain course. Contrast that to strict liability, where it doesn't matter what you intended. If you did what you did and it was against the law, then you can be found guilty. The defendant may, however, plead honest and reasonable mistake of fact, and those of you who did the assignment in relation to changes to the Vegetation Management Act may have picked up on that point, that there has been a reintroduction of the honest and reasonable mistake of fact defence, which is section 24 of the Criminal Code, in relation to those matters. Finally, there's absolute liability. There's no defence can be pleaded, and that's pretty rare. 18.44, maximum penalties for strict liability are generally lower than for crimes committed with intent. This reflects the fact that intention is not required for crimes of strict liability. And in Australia, as I mentioned, it's rarely been interpreted that environmental offences are of absolute liability. That's almost unheard of, really. Okay, 18.48, offences involving mens rea, which is the element of intention. And that's an essential ingredient if it's designed in the legislation as being a matter which involves intention. But intention can also be catered for or created through willful acts which are reckless or negligent. So Bates goes on to talk about a willful intent as opposed to recklessness and negligence. And willful intent, he says, intention may be established by direct evidence of actual intent or by constructive intent. That is, you can draw an inference from the doing of an unlawful act and the circumstances and conclude that the accused knew all the facts and constituted the ingredients and was involved in the intent of doing so. Willful blindness, that is a reckless disregard for the facts, may be treated by the courts as equivalent to actual knowledge for this purpose. Recklessness means that they've acted in a way where a particular consequence was probable or possible from his or her conduct. So, if you were to, in the dark, wield an axe, and as a result of that, a wall was damaged, you might say, I didn't know the wall was there, I didn't intend to cause the damage, but a court may say you're still guilty of willful damage because of your recklessness in terms of what you did by wielding the act in the manner that you did. So you can still be found criminally liable even though your actions are negligent. Then goes on to talk about negligence, and there's some comments in relation to knowledge as well. Okay, I'll just move forward now. There's 18.55 deals with vicarious liability, which is a term applied to a situation where one person is held liable for the actions of another. That's usually not in the criminal law context. Over the page, the test as to whether one should be liable for the actions of another, particularly in an employment situation typically, is whether the one person had sufficient control. So if an employer purports to exercise detailed control over the manner in which the work is performed, then the employer is likely to be found liable for the acts of the employee or contractor. So if the employer specifies that this is what is going to be done, this is how we're going to deal with these pipes which are transporting oil, and something happens, it's no defence generally for the employer to say, well, I'm not the one who actually did it. They can be vicariously liable for the actions of their employees in those circumstances. At 18.57, where the requisite degree of control is not apparent, however, then in the absence of any statutory interpretation to the contrary, the employer will not be liable. Environmental protection legislation often introduces a clearer statutory imputation of vicarious criminal liability. EPA Section 492 is an example. And then Bates goes on to quote or deal with the matter of emissions from ships. And in that instance, usually both the master and the owner will be liable. Over the page, vicarious liability of a corporation. A corporation, as a legal person, is subject to the same offences as a natural person. That may come as a surprise, but that's the position. The general principles of corporate criminal liability stem from the House of Lords decision in Tesco, where a corporation would only be liable for negligence of its top level management. The Tesco principle has been replaced in most statutory schemes for environmental management. So vicarious liability of directors and managers at 18.63, it's usual for the environmental statute to provide that where a corporation has committed an offence, then directors, other managers of the corporation, are deemed guilty of the same offence. Now, if I was involved in acting as a director or manager of a company associated with environmental law activities, I'd be very, very concerned about that section. And here it is tucked away at the bottom of page 805, but in my view, extremely important. At 18.65, in Queensland, a company director may be held liable to a term of imprisonment for failure to ensure that the company complies with various provisions of the Environmental Protection Act. That's section 493. Where a company is effectively the alter ego of the directors, then the court is apt to treat the responsibility of those directors personally. Bates makes reference to Australian Pacific Oil. The company was fined $20 for an environmental offence. However, the directors were fined $40,000 each, and the directors had to pay costs totaling $55,000. What the court did in that instance is effectively, this is a term that lawyers like to use, lift the corporate veil, essentially saying, fine, we're dealing with ABC Proprietary Limited, but let's just strip that away. Who is ABC Proprietary Limited? It's you two. You're the ones that profit, you're the ones that control. So, okay, technically ABC is guilty. We'll fine the company $20, but I'm really attacking you two in terms of the orders that are to be made. Double jeopardy. 18.69, the basic principle is that a person can't be convicted twice of the same offence. Individual can't be charged twice for different offences, even if they arise out of the same set of facts, or may be charged, sorry, for different offences. That whole area of law is currently under review, and you may be aware that the State Attorney is currently considering overturning the double jeopardy rules. Let's talk about defences. That starts at page 809, and those defences are available for offences involving mens rea and strict liability offences. They may be due diligence or reasonable conduct, or it might be a reasonable mistake of fact, provided it's also honest. Due diligence. It's often been a defence that a commission of an offence was due to causes over which the person had no control, and the person took reasonable precautions and exercised due diligence to prevent the commission of the offence. Okay, there's an oil slick over the reef, but I did everything possible to ensure that this would not have happened. That's a defence of due diligence. In practice, says Bates at 18.72, like the defence of honest and reasonable mistake, the defence of due diligence is very difficult to make out. Due diligence contemplates a mind concentrated on the likely risks so as to prevent the contravention that actually occurs, and general precautions will not suffice. I'm sorry that there's an oil slick on the reef, but I do make sure that my ship is maintained by regular maintenance every 3 months. Not good enough. Tell me what you specifically did to ensure that there would be no leakage from the section of the boat where there was a leakage, for example. Honest and reasonable mistake of fact, section 24 of the Criminal Code. The honest and reasonable mistake of fact is available as common law under a statute, but determining whether the mistake is one of fact or law is notoriously difficult. For example, you're driving along, you're picked up for speeding, you say to the officer, I acknowledge that I was doing 80 kilometres per hour, but I thought that the speed limit in this area was 80 kilometres per hour. The officer establishes that in fact the speed limit in that area was 60 kilometres per hour. Have I made a mistake of fact, or have I made a mistake of law? It's only a mistake of fact which can be relied upon, provided it's reasonable, as a defence in those circumstances. The answer to that question is, I made a mistake of law, not fact. So the defence of honest and reasonable mistake is only available to offences of strict liability, not offences that require specific intention or knowledge. If the defendant can raise sufficient evidence on the balance of probabilities to indicate the defence might apply, then it is for prosecution to disprove the defence beyond reasonable doubt. That's the way it always works in criminal proceedings. So if your defence is one of self-defence in an assault situation, once you have reasonably raised the defence, then prosecution must discount it beyond reasonable doubt. That makes life difficult for prosecutors, but it's not just environmental law, that's generally the case. At 17.87, Bates makes reference to Cooper against ICA. Caltex Oil transferred a quantity of distillant by pipeline to premises operated by Esso. The defendant modified the line. The modifications proved defective. The oil spilt into Botany Bay. The court held that ICA's belief in the condition of its pipeline, that might have been an honest belief, but it wasn't reasonable. And the defence of honest and reasonable mistake requires both, and therefore in this instance the defence would not apply. At 18.80, other circumstances that might apply would be officially induced error in circumstances where the defendant is misled by advice from government or local government officials. So in Palmer's case, the High Court dealt with a contravention for fishing in a marine protected zone, but the person was misled by official advice from Western Australian Fisheries Department. The High Court said, well, somewhat sadly, the conviction must stand, but prosecution should never have raised this issue. They should not have prosecuted, because this was an instance of officially induced error. 18.83, Booth and Frippery, Queensland Court of Appeal had to consider a curious and novel defence, and that is, by unlawfully harming bats by constructing electric grids to protect a lychee crop, that was the unintended consequence of an otherwise lawful activity. Over the page, the court said, if a defendant intended that the activity should result in taking a protected animal, the defence is not available, regardless of the motive. There seems to have quashed any suggestion that there could be a defence of unintended consequence. At 18.90, Bates raises a number of issues where directors and managers can take steps to remedy situation. And then at 18.92, he talks about sentencing principles, and in particular that sentencing serves a number of purposes: to ensure the offender is adequately punished, to prevent crimes by deterring others, to protect the community, to promote rehabilitation, to make the offender accountable, to denounce the conduct, and to recognise the harm done to the victim. At 18.95, and this is generally the case in criminal law, the deterrence aspect of sentencing is vitally important. It's already been said in the past, environmental crime tended not to be regarded, particularly in the lower courts, as real crime, but that's changing. At 18.96, although a court may well look favourably upon settlements negotiated between prosecutor and accused, which is sort of through case conferencing or plea bargaining, making orders that reflect the terms which have been agreed is subject to the court exercising its duty not simply to accept the deal, but to determine the appropriate penalty. I'll just stop there. It's very common in criminal law proceedings for negotiations to take place. It was, until very recently, very common for submissions to be made by prosecution and defence as to what is an appropriate penalty, particularly given that the matter has been the subject of a negotiated settlement. Courts have always had the view, correctly, that they are not bound to agree with what the parties have come up with themselves, but must always determine their own penalty. In the last month or two, we've seen a further development. The High Court in the Barbaro decision has now concluded that prosecutors are precluded from making submissions on penalty, generally speaking, anyway. So typically, prosecutors used to say, in relation to this matter, let's say grievous bodily harm, the appropriate range for head term of imprisonment is, let's say, 3 years for the prisoner to serve actual time of 1 year. Prosecutors can't do that anymore. Defence can, according to, in my understanding, most judges and most magistrates, but there are exceptions to that.
Yeah, John?
Yes, Rodney?
Just getting back to the matter that you're talking about, in a way, it sounds like when they were doing a negotiated agreement, they were actually skipping the judgment part of the judge as regards to penalties and stuff like that.
Yes, that's right.
Because they're trying to get rid of the judge and trying to get something that's favourable for the criminal instead of him facing his full punishment.
Well, certainly, from a defence perspective, which is where I practice, the attempt is to provide some certainty to the situation. But there is a trade-off, of course. By having a negotiated settlement, then prosecution don't have to run a trial, which carries with it cost and inconvenience and stress to witnesses, and also takes away some uncertainty for prosecution as well. So, look, I'd agree with your general proposition that plea bargaining probably is of greater interest to defence rather than prosecution, but there is still some trade-off there both ways. But of course, where I would disagree is that that can never be the substitute for the role of the judge. The judge will always impose his or her decision, irrespective of any deal that might have been struck by prosecution. That's particularly the case after the Barbaro case. Sorry, Rodney, does that answer your question?
Yeah, it just seems what you're saying, it seems to be a bit odd that they're agreeing to something to skip out the judge, but then I realise that the judge, he says, fine, you want to do that, fine, but I'll still have my say in your...
Exactly, so yes. That's it, exactly. All right, 18.99, in Plath and Rawson, Chief Justice Preston undertook a review of cases where imprisonment had been imposed in environmental matters and came up with some issues that are important. So, has the conduct been willful and deceptive? Was the conduct to make a profit or save an expense? Was there a high level of risk to or actually caused considerable harm? Was the conduct over an extended period of time or repetitive? And is deterrence appropriate to make custodial sentences more appropriate? For public bodies, the court may adopt an attitude of sentencing that reflects the fact that public authorities should lead by example. All right, we're getting close. Thank you for bearing with me. Could I take you now through to part 107, sorry, where there are a list of aggravating or mitigating factors, and I'll get you to read that for yourself, but this is pretty common. Section 9 of the Penalties and Sentences Act in Queensland has something somewhat similar to that for consideration by courts in general criminal law proceedings. All right, there's other options, as we discussed, available to courts, generally speaking. Okay, well, thank you for your patience. That's all I propose to talk to you about in relation to Chapter 18. At some stage, I do hope that I'll have a special Zoom session, commentary in relation to Chapters 19 and 20, just to round out the book. Are there any questions or comments? All right. Well, at this stage, I'll stop recording and thank you very much.